All right. We're ready to begin, everyone.
We're ready here in courtroom 2, Judge.
All right, thank you. All right, good afternoon. We're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after the arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to handle matters including bond, possible arraignment, or a possible plea offer if one has been made by the state at this juncture. I'm also going to be providing you with an SAP reset date, and that date is
June the 26th.
June 26th. June 26th. I also want to begin by reminding everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. Also, I want to remind the defendants on this calendar that you do have certain constitutional rights. The first being that you have a right to counsel or representation at this point, and you should have spoken to your attorneys and know who they are by this time. So please follow their lead and listen to them. You also have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be held against you. The state is here, they're listening. So again, follow the lead of your attorney. Who do we have first?
Position 2, Ms. Amos.
All right. That's 25 CR 003318G. Takia Amos, charged with 1 count of battery family violence and a 2nd count of simple battery family violence.
You got my list?
I'm still printing.
All right. This is the first arrest, though. She's a resident of Mississippi.
I don't see yours. State.
Good afternoon, Your Honor. How are you?
I'm fine. How are you?
I'm doing good. Okay. So the state is asking, requesting a $3,000 surety bond. No contact with the victim, no drugs, no alcohol, no weapons. 1 day of anger awareness and to stay away from the incident location, which is 650 Ponce de Leon Avenue, Northeast in Atlanta. On June 12th of 2025, the officers were dispatched to 650 Ponce de Leon Avenue, Northeast in reference to a dispute. Upon arrival, the officer spoke with the defendant and the victim. The victim name is Gentavious Chercy. Hope I'm pronouncing that correctly. The officer separated the two to receive both sides of their statements. When he spoke with the defendant, she stated that her boyfriend, who is the victim, came from Mississippi, and they had been staying inside of her car for about a week and a half. The defendant stated that the victim is jealous and hits on her because he is a jealous man, and defendant has stated that he pulled on her clothes, but he did not hit her while they were inside the vehicle at the location. Defendant stated she struck him because, quote, she wanted to get her lick back and wasn't going to let him talk to her like that in front of people. The defendant did not have any bruises, scrapes, or scratches on her body, on her person. The officer then spoke with the victim, who stated that he was struck in the nose numerous times by the defendant and had blood on a washcloth. The victim stated that they are homeless and have been staying in the vehicle. There was a witness, Christian Washington, who stated that she observed the defendant hit the victim numerous times while they were in the vehicle. The defendant and the victim do not share any kids together, but they have been staying together for approximately 2 years. The defendant also stated I'm sorry, after that, the defendant was arrested. And so the state is asking for 3,000 surety, no contact with the victim, no alcohol, no drugs, no weapons, 1 day of anger awareness, and to stay away from the incident location.
All right, PD?
I'm sorry, what did you say?
I said the PD Tucker.
Yes, Your Honor. Ms. Amos is 23 years of age. I know it was stated that she is a Mississippi resident, but she was actually able to give me a local address at 363 Foster Avenue, apartment 163. So she is currently an Atlanta resident. She's completed up to a 10th grade education. She currently has a 3-year-old child who she is the primary caregiver for. We are requesting a signature bond on her behalf. As it was stated, she has no criminal history. This is her first arrest. Therefore, she has no prior failure to appears. She lives in the area. There's no reason to believe that she won't appear for court. Um, we are requesting that she be allowed to return to the incident location of the address that they were at on Ponce. She was actually there for a job interview, and she was told by the manager that she could return once this situation was handled to actually conduct the interview, to potentially gain employment. She is not employed at this time. And we will also object to the request for no contact and ask for no violent contact. Both parties did just relocate from Mississippi and currently reside together. So again, we are requesting a signature bond on Ms. Amos's behalf.
I am a little concerned, will the victim be staying in the and I don't know, Ms. Githier, if you have this information, you all have interviewed the victim. I'm a little hesitant in sending the defendant back to, I guess the incident location is not where they live, or is it?
No, ma'am, it's not where they live.
Okay, so this Ponce de Leon address is
It's
not.
a restaurant.
Oh, okay.
At the time, they were staying in her car, Your Honor.
And I'm concerned about that, and that you know, if the defendant is truly a resident or not, or just gave us an address, to make sure that, you know, she will come back, although it is her first arrest. All right, I'm going to order a $3,000 signature bond through pretrial per judge at a level 2. I'm going to order 1 day of anger awareness course through pretrial. I'm going to order that she stay away from the incident location, which I understand is a restaurant. I'm going to order, since this just happened less than 24 hours ago, I'm going to order a no further contact with the victim. Stay away from the victim 200 yards. Obviously, they shouldn't be living together or staying in the car together. No contact by cell phone or anything else. No drugs, alcohol, weapons, or guns while on bond. Anything else, counsel?
Judges is 1,500 each.
Yes. All right.
Position number 5, Mr. Sherman Bell.
Okay. 25 CR 003313D Sherman Bell 1 count of battery family violence, 2 counts of simple battery family violence. Pretrial?
16, on probation, possession of a firearm by a convicted felon or felony first offender. He has an open case for fleeing an officer and speeding. Open marijuana case. Possession of drug-related objects, loitering and prowling out of Clayton County. He has a felony probation hold. So 2024 FTA, 23 FTA, 2017 18 FTA.
All right, state.
Yes, Your Honor. The state is requesting a 10,000 surety bond in this matter, as well as no further violent contact with the victim, no alcohol, no drugs, no weapons, an evaluation for alcohol and drugs, a 10 p.m. curfew, and 3 anger awareness courses. On March 28th of 2025, the officer responded to 3041 Landrum Drive Southwest, apartment 32C, in reference to a reported fight. And upon arrival, the officer made contact with the victim, Aaliyah Dillingham, and she had stated that she had been assaulted by her child's father, which is the defendant, Sherman Bell. The victim stated that she was in the shower when the defendant knocked on the door with their 2-month-old daughter. The victim stated that when she answered the door when she got out of the shower, and the defendant was upset because he was upset with her because he assumed she was in the apartment with someone else because she was in the shower. The two got into a verbal altercation. The victim stated that during that argument, the defendant punched her in the face with a closed fist and pulled her hair and grabbed her arm. And the officer did note bruising on the inside of the victim's arm. The victim stated that the defendant fled the scene when she called the police. The defendant was not on scene when the officers arrived, but the victim was able to positively identify him by a photograph and stated that he resided with his mother. And the investigator was informed of the incident given the photograph of the defendant. Given the defendant's lengthy criminal history and some of these particular charges, as well as this recent charge, the state is requesting a $10,000 surety bond, no further violent contact with the victim, no alcohol, no drugs, no weapons, the alcohol drug evaluation, a 10 p.m. curfew, really because just given his lengthy history, and also the 3 anger awareness.
How old is the defendant?
He is 25 years old, Your Honor.
Okay. TDs? Ms. Strong, are they on or signing on, or who is that with no picture?
I'm thinking it's Mr. McLean. He's unmuted, but I don't see him on.
My video says it's muted by the host.
His attorney is Ms. McLeod.
Ms. McLeod is on.
You're muted.
My client.
Okay. Hey, Ms. McLeod.
Good afternoon, Your Honor.
Good afternoon. Is this your client, Ms. McLeod, Sherman Bell?
Sherman Bell is my client, Your Honor, yes.
Okay.
I'm sorry, I did not hear what the state said because somebody was calling me at the same time.
Oh, they're recommending a $10,000 surety bond, ADT, no further contact, and 10 p.m. curfew, 3 anger awareness courses. And I better stay away in there, Ms. Githiel.
I did not.
No, Your Honor.
Also apologize, I did not hear the history.
16.
Okay.
And who wants to give a summary? And he's on felony probation hold. But I don't believe he's going anywhere.
I understand.
It's not a good history.
Okay. All right. Well, I'm just sorry I didn't hear it. But, Your Honor, I have spoken with my client and he's not currently employed. I was not able to speak with the alleged victim. So I can't really say what her feelings towards it. And unfortunately, I've also not yet seen a copy of the warrant. So, I'm not in a position to tell the court what really I believe is going on in the case, other than the little discussion I have with my client. I do know this, that he's currently unemployed, so he certainly is not in a position to pay for a bond. He has no income at all whatsoever. But he tells me that in the event the court determines that he and the alleged victim can no longer live in the same household, that he has somewhere else to go. I would like to point out to the court that they share two minor children, very young children. My understanding is one is only 4 months old, and there is also a 1 year old. So I would definitely want him to have contact with these children because kids need their father. So I would ask the court to take that into consideration.
All right. With the history that he has, and he's got a probation hold, the state requested a $10,000 surety bond. I'm going to grant that $10,000 surety, which will be 5,000 on the battery and 2,500 on each of the simple batteries, to total 10. I'm going to order that he stay away from the incident location and have no further contact with the victim if we've not heard from her to know what's going on. I'm not going to order.
I'm on the call now. I'm the
Excuse me?
victim. I'm sorry.
Need to see you.
Hold on 1 second.
And Your Honor, it was no further violent contact with the victim.
And that's because the state has spoken to her?
Yes.
Okay.
You're
May-
not,
Hurry up and get
not hear from her at all.
I'm on the call.
Okay,
I'm
you-
sorry, Ms. McLeod, I didn't hear what you said.
for
I
me.
was asking if we would be hearing from Miss Dillingham.
If she sits down and gets into the camera correctly, I can only see her forehead and one eye.
Can you see me now, ma'am?
Yes. Can you raise your right hand for me? Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
Okay. Do you have on clothes or pajamas?
I got on pajamas.
Okay, you can't come into the court with pajamas on. That's
Okay.
not proper dress. This is proper court, so you must have clothes on. I'll
Okay.
give you seconds if you can grab a top or blouse or something to put on. We can't wear pajamas.
Okay.
Turn your camera off. And your okay. Ms. Strong, do you see that for Mr. McLean?
Yes, ma'am. And Mr. McLean, Ms. Grace said the translator case is gonna need to be reset if that's the Mandarin, I'm assuming, because we're not able to get a Mandarin interpreter today.
Right. I can unmute my audio, but I can't unmute my video. But yes, hope we do get a oh, I can try to start video. I'll get out and come back in.
Okay.
Very strong and Judge.
I'm
Ms.
sorry.
Young sent me something, Ms. Strong, and hopefully we may have one on in about 20 minutes.
Okay. We can see you now, Mr. McLean. Well, and I'm gonna give about 1 second for this victim, or else I'm going to move on. I'm not going to let her hold me up today. All right, Ms. Dillingham, you ready?
Yes.
All right. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
You wanted any further contact with Mr. Bell?
Yes.
And I understand you all have two small children together.
Yes.
All right. And are you afraid of Mr. Bell?
No.
Okay. All right. I don't have anything else. You can mute yourself. Okay. Thank you. All right. Go ahead. Oh, that's right. We already heard from Ms. McLeod.
Yes, Your Honor.
Okay. I'm going to stick to my ruling about the $10,000 surety bond. I will allow no further violent contact with the victim. And I realize this happened back in March. So I guess if there's been no additional incidents since then, hopefully everyone will be safe. And this curfew state, I'm not sure the purpose of the curfew for an adult. So I'm just not going to, I'm not going to order the curfew. Not going to order the anger awareness courses. I'm not going to say anything about visitation because the children are just too small. I'm not going to order it. I'm not going to order an escort or anything like that. That'll be up to the victim if she wants to allow visitation. No drugs, alcohol, weapons, or guns while on bond. And I believe that's it. So no further violent contact. And I guess no, it doesn't matter. There won't be a stay away.
Thank you, Your Honor.
And Your Honor, the state had also asked for an evaluation for alcohol and drugs, given some of the many charges.
Right, I understand.
He's in jail.
Yeah, I'm not gonna order that at this point. And if he's unemployed, he's not gonna be able to pay for it anyway.
No.
Okay.
Yeah, I'll do that later. All right, now.
Thank you, Your Honor.
Thank you. Is that your only one, Ms. McLeod?
It is, Your Honor. May I be
Okay.
excused?
Yes, you may. Have a good weekend.
Thank you, you too.
All right.
Position number 3.
Okay. 25 CR 0003311E, Layla Artora, charged with 2 counts of simple battery, family violence.
First.
First, I see it now. Okay. State.
Yes, Your Honor. The state is requesting a $2,000 surety. No further violent contact with the victim, no alcohol, no drugs, no weapons, and 1 day of anger awareness. On June 11, 2025, the officers were dispatched to the Landing Square Apartments located at 3378 Greenbrier Parkway Southwest in Atlanta regarding a dispute between the husband and wife, the victim and the defendant. I'm sorry, the defendant and the victim. Upon arrival, the officer spoke with the defendant about the incident. Defendant stated that she and her husband, the victim, Jeremiah Aurora, were in a verbal altercation inside of the apartment before it became physical outside. Defendant stated that her husband had their child in the car seat and wanted to take the child to his mother's home in her vehicle. Therefore, she said she pushed and punched him while he was holding the car seat with their child inside the car seat. The victim stated he was going to his vehicle with their child in the car seat when the defendant came down yelling about not taking the baby in his vehicle. The victim stated that the defendant pushed him and started punching him, and he attempted to push her away so the child wouldn't get harmed in his during his altercation. There was a witness by the name of Tredarian Hatton, who observed the incident when defendant physically attacked the victim. And the witness stated that he tried to step in between the two as the defendant was punching the victim. The victim was punched by the defendant with a closed fist on his chest. And as a result, the defendant was detained and placed in the rear of the officer's patrol vehicle. Given that this occurred, not only was this just an incident between the husband and the wife, this was a young baby that was in a car seat. And just regarding the safety of that child, the state is requesting a $2,000 surety bond, no further violent contact with the victim, no alcohol, no drugs, no weapons, and 1 day of anger awareness.
All right. PD Tucker, or is it McLean? I'm not sure which one.
This is my case. I wanted to restate it on the record. Her last name is Aurora, is misspelled. So it's spelled Arora.
Oh, okay.
So it's Layla Aurora. She is an Atlanta native, 21 years of age. Um, she's completed high school. She's currently employed at Glasses USA, which is a recent employment. She just started there this month. As it was stated, she does have a minor child who she's the primary caregiver for, a 9-month-old baby, and she is currently 6 weeks pregnant. This is her first arrest. She has no criminal history, so it is appropriate that we request a signature bond on her behalf for these specific charges. We have no objection to no further violent contact, as well as the other recommendations from the state.
All right, Mr. Jeremiah Aurora, what is your relation to the defendant or the victim?
She's my wife.
All right, so you're the victim.
Yes, Your Honor.
Do you wish to address the court briefly today?
Yes, Your Honor.
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right, put your hand down. Are you in fear of Miss Layla Aurora?
No, Your Honor.
Do you want to have any further contact with her?
Yes, Your Honor.
Okay. All right, thank you for getting on the Zoom. All right, I'll go ahead and give my ruling. I'm going to order a $2,000 signature bond. And that signature bond, because of the charges, are these restricted? They have to go through pretrial? Or not,
I
Ms.
mean, they
Vicky?
restricted, but you can do it as you please. So,
Yeah, all right, I'll let him go through the jail.
I mean, it can come through preach. I'm just saying they are
Right,
restricted because it's domestic violence.
because it's DV. Well, let me change it and just let him go through pretrial. 1,000 on each, so that'll be 2,000. SOB pretrial, level 1. I'm going to order the 1-day anger awareness course. No further violent contact with the victim. And no drugs, alcohol, weapons, or guns while on bond. And that'll be it.
Number 11.
All right, 11. Okay. This is 25 CR 003305A, Maria Montgomery, charged with 1 count of giving false information to law enforcement, tag light required, driving while license suspended or revoked, possession and use of drug-related objects, possession of marijuana less than an ounce, and tampering with evidence.
6 on probation for DUI. 2019 battery first offender. 2019 selling marijuana dismissed.
Okay.
My case, Judge. Good afternoon.
Hi, how are you?
Good, good. So this incident took place June 12th, 2025 at Haynesbridge Road near Georgia 400. in Alpharetta. Law enforcement saw a vehicle that had an inoperable tag light and conducted a traffic stop. Upon approaching the vehicle, the officer made contact with the driver, the defendant, and requested her license. She stated she lost it and provided a false name and date of birth, those being Christina Montgomery, DOB February 6, 1995, stating that her license was out of Virginia. When the officer ran that name and date of birth, returned to a different individual that looked nothing like her. And upon reapproaching the vehicle, from the other side, the officer smelled a strong odor of marijuana coming from the vehicle and had the defendant step out. She denied having marijuana, but stated there was a grinder somewhere in the vehicle that she didn't know where it was. Vehicle was searched. Upon that search, the officer located her actual ID, which confirmed her identity. When the defendant's real info was run, her driver's license returned as suspended. And during the transport to the jail, the officer observed the defendant wriggling around in the back seat of the patrol vehicle. The officer pulled into the lot and discovered the defendant destroying marijuana in the back seat of the patrol vehicle. She had a jar of marijuana shoved in her genitalia, which she dug out while she was in the back seat, and then dumped it all over the seat, began destroying it. Her license has been suspended multiple times. Once in 2021, it was canceled in 2022, suspended for in 2024 for the refusal of the implied consent, which she was ultimately convicted of that DUI, as pretrial stated. There was also a driving while license suspended, a revoked charge originally that was amended to a non-fingerprintable charge. Aside from that, I see arrests for possession with intent to manufacture, sell, distribute marijuana. That was from 2012, dismissed in North Carolina. And then purchase, possession, manufacture, distribution, or sale of marijuana in 2019. Conditional discharge program, looks like she completed. That was in Columbia County. So defendant shouldn't be driving around, continues to drive around without a license. And this isn't her first case involving possession of drugs she's not supposed to have. So the state's asking for $3,000 surety, total $500 surety for each count, no driving without the proper licensure and other documentation, and no drugs, weapons, or alcohol while on bond.
All right. PD McLean.
Thank you, Honor. Ms. Montgomery is 31. She's a high school graduate. She works in the field in which she does cosmetic type things for folks like nails and that sort of thing, the beauty industry. I do understand the arrest record. We would ask the court to consider under these circumstances, possibly, if not a signature bond, we would ask for that. But if not a signature bond, if the court does not feel that's appropriate, then we would ask for a $100 to $1,500 surety bond. Thank you.
Okay. All right, I will order the $3,000 surety bond. That's $500 on each. And with that surety bond, is that the right math? I was just making sure. 16. Yeah.
That was the state's recommendation, Judge. Yeah, what, 500 on each?
That's 3,000, isn't it?
Yeah. What did I say? I might have said something wrong.
It
3,000.
sounded like 2, but I could be wrong.
That's okay. 3,000, 3,000 surety, 500 on each. And I'm going to order no driving unless she has a proper license and registration, other things for the vehicle. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else, counsel?
I believe that.
Your Honor, I did reach her friends and family, and I will call them after court and tell them the disposition of today's hearing.
Okay. All
Thank you.
right. All right, thank you.
Number 14.
This is 25 CR 003309Y, Hillary Rodriguez. Charge of 1 count of battery, family violence, 2nd count cruelty to children, 3rd degree.
Second arrest, 2009 obstruction dismissed.
Okay. Date?
Thank you, Judge. This incident took place May 24th, 2025 at 4019 Hammock Trace in South Fulton. Law enforcement responded to the scene and made contact with the victim in this case, Mr. Travis McDonald. He explained that the defendant, the mother of his child, had come to his residence on 2 separate occasions. The first visit was about 3 in the morning, dropped off a bag of clothing for their daughter, juvenile HM, a little over 1 year old. Despite an agreement that the victim would get clothing from her residence, the defendant returned to the victim's residence later that day, around 9 at night, holding their daughter, claiming the child was sick. When the victim offered to care for the child, the defendant refused. And the victim asked why she was there. Defendant stated that she was there to see if he had another woman inside the residence. Defendant became verbally aggressive, things got heated, and he repeatedly asked her to leave. The defendant was seen rummaging through his truck and holding his dog as if she was about to throw the animal. And then the defendant attempted to enter the victim's home, and while holding the daughter during the struggle at the door, she managed to force it open, striking the victim in the forehead with the door, causing a laceration. Defendant also threatened the victim, saying that if he called law enforcement, wouldn't be allowed to see his daughter again. And after the victim started contacting law enforcement anyways, the defendant fled the scene. And he was treated on site for his injuries. We have spoken with the victim here. He explained that they're not in a relationship, don't live together, but do share the 1 child, confirmed the events in the warrant, and he explained that this is not the first time the defendant has shown up to his house unannounced and been violent towards him. He explained that he's called the police in the past, but the defendant would always leave the scene before police would get there. He has since filed for a TPO, which we're happy to hear was served upon her arrest. And he stated he wants no contact with the defendant and wants her to stay away from his residence. He should be on the Zoom if we could sound for him. Given the account of their history here that Mr. McDonald's graciously provided, we are concerned for his safety, and there is a risk of reoffense, so the state is asking for a $4,000 surety, $3,000 on the battery family violence, $1,000 on the cruelty to children, for her to complete FIB, have no further contact with the victim, stay away from 4019 Hammock Trace in South Fulton, and no drugs, weapons, or alcohol allowed on bond.
All right. And
That'll be mine.
okay, McLean.
Your Honor, she does staffing work, administrative work for a human resources staffing firm. She's in the human resources department, rather, of a staffing firm. And so her work is administrative in nature. She's 35. The situation is such that we feel that a signature bond would be appropriate. She hasn't been in that much trouble with the law in the past, and this is almost like a first arrest. I don't think she had a conviction before, so we would ask the court to look at that in particular and grant her a signature bond. Their addresses are certainly not the same, and she can obey the court order. and follow all appropriate, follow anything the court orders, as far as conditions go. Maybe premature for an FVIP, but a day or two of anger awareness would be perhaps more suitable. Thank you.
I hope she can. It sounds like did the state talk to, the state spoke to the victim father, correct?
Yes.
And if he's getting ready to seek a TPO, it sounds like she won't stay away, or he has the child with him. Is that correct?
No, Your Honor. I think maybe I'm mixing up police reports in my mind, but I think this is one where the child would have to go through a proceeding.
All right. I'm going to order the $4,000 signature bond through pretrial. 3,000 on the battery, 1,000 on the cruelty. And she can be at a level 1. I'm going to order 2-day anger awareness course, 2 days through pretrial. No further contact with the victim, Travis McDonald. Stay away from his residence, his work, wherever he may be. She should be 200 yards away from him. If there's visitation allowed with the daughter, then that should be precipitated by a third party so that she doesn't violate the conditions of her bond. No drugs, alcohol, weapons, or guns while on bond. And I think that should be it. Anything else?
Thank you.
I think that's it.
No, thank you. That's it.
Position number 9, Mr. Jenkins.
And Ms. Johnson, I don't know what case you're here for, but I will not allow you to speak or participate if you're driving and moving in your vehicle. You need to pull over, or you turn off your camera as well. It's distracting what you're doing. Nine is 25 CR 003317C. Akpan Jenkins. 2 counts of abandonment of dependent child. You can give me that pretrial, but I know what I'll say to this charge.
Yeah, ain't nothing to give. I mean, he been in custody since March on felony. So.
Okay, so that's fine. The purge amount is the purge amount. There's nothing I can do for that. You can tell us what it is, someone. What's his purge amount on both of these charges?
I have $387, Your Honor,
On each?
total.
Oh, what is it for? Tell me
Let me just double
breakdown.
check. Let me just double check.
Yeah. I mean, it's possible that it's that low, but I'm surprised, but it may just be 1 month's worth of child support. Is it, Ms. Tucker?
Yes, Your Honor, it's 1 month's child support, 387.
Okay, so what is it for each charge? I just wanted the breakdown. It's 387 total.
Is it 2 counts or 1 count?
I see 2 counts, and that's why I'm asking. There's 2 counts. How much on each count? Somebody.
It's a total of $387 for both of them, total.
Does anybody have a copy of the warrant application? Because it'll determine if it's 2 children. I'm trying to pull my Odyssey back up. That's why I'm asking.
Yeah, it has 2 children listed.
So it's like $193.50 a piece, Judge.
Thank you. That's what I'm asking. But depending on how old the order is, the old ones, they used to put 2 kids on one, but now they separate them because obviously they'll age out at different times unless they're twins. I don't know.
This one was dated April 16th of this year.
The order?
I'm sorry, that was the arrest warrant. I'm sorry.
All right, his purge is $387. That's it. That's the only way he can get out is to pay his purge. But if he's on a felony hold, I guess he's not going anywhere. So no drugs, alcohol, weapons, or guns while on bond. And that's it.
Number 1.
Okay. This is 25 CR 003310J Billy Acevedo. 1 count of battery family violence, a 2nd count of simple battery family violence. And this is first arrest for pretrial. All right, state.
Yes, Your Honor. The state is requesting a $3,000 surety, no further violent contact with the victim, no alcohol, no drugs, no weapons, and 1 day of anger awareness. On June 12th, 2025, the officers were dispatched to the incident location of 1702 Tree Lodge Parkway regarding the domestic disturbance. The officer made contact with the reporting party, Brian Jones, and the victim, Tatiana Jones. Miss Jones, the victim, stated she had been in the apartment complex pool earlier that evening with her husband, the defendant, and her niece, Summer Jones. Both she and the defendant had been drinking excessively and were heavily intoxicated. As a result, an argument began between the two while Miss Jones was seated at the bar stool when the defendant approached the victim and pushed her backwards off the bar stool, causing her to fall back and strike her head on the concrete. The victim sustained a cut on her knee and her finger. The niece, Ms. Jones, also corroborated what the victim had stated, stating that she witnessed the push and the subsequent fall as that occurred from the push. Mr. Brian Jones, who made the call, stated that the defendant was refusing to leave the apartment. He then called 911 to request law enforcement, to come and intervene. And before the officers arrived, the defendant had left the scene. The defendant was later located in a parking lot of a hotel at 5793 Roswell Road, and the officer made contact with the defendant, and he admitted that he had argued with his wife, though he couldn't recall the reason for the argument due to his level of intoxication. He further admitted to becoming upset and pushing her during the argument. It also should be noted that he was in the passenger seat when they located him at the hotel. He was not behind the wheel. And based on the injuries, the corroborating witness statements, and the defendant's own admission, he was placed under arrest. So again, the state is requesting a $3,000 surety bond, no further violent contact with the victim, no alcohol, no drugs, no weapons, and a 1-day anger awareness course. Nothing further from the state.
All right, PD Tucker, but I do see the victim on. You want to go first, or the victim to go first?
I apologize. Ms. Tatiana Jones is on the Zoom.
All right, do you wish to address the court today, Ms. Jones?
Good evening, Your Honor. Yes, I can.
Raise your right hand. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, I do.
All right. And are you in fear of Mr. is it Acevedo?
No, Your Honor, I am not.
Do you want to have any further contact with him?
Yes, I do.
Okay. Do you all have children together?
No, Your Honor, we don't.
Okay. All right. I don't have any other questions. Anyone else? All right, you can mute yourself. Thank you. All right, PD Tucker.
Yes, Mr. Acevedo is 25 years of age. He's lived in the Atlanta area for about 2 years. He has completed trade school. And prior to this incident, he has no criminal history. So of course, no prior failure to appears. So it is appropriate that we request a signature bond on his behalf. He has lost his employment due to his incarceration and missing work. So he also now has income issues and would have an issue paying for bond. And again, because of his lack of a criminal history, it is appropriate in this case to request a signature bond for him.
Okay. All right. I will order the $3,000 signature bond through pretrial. That'll be at a level 1. I will order no further violent contact with the victim. No drugs, alcohol, weapons, or guns while on bond. And I guess I won't order an anger awareness or anything like that. The pretrial, we'll just hold off on that and see where the case goes. But I do understand it. The allegations are that both parties have been drinking. I was going to order AA, but I'll hold off on that as well. And that should be it.
It was
Thank you, Your
1,500
Honor.
apiece, correct?
1,500 apiece, yes.
Position number 15, Mr. White.
Okay. This is 25 CR 003319C, Ronald White, charged with 1 count of criminal trespass.
14. The last arrest was 2015 for a CWAC charge, not prosecuted. 2011, possession of tools, trespass, not prosecuted. I didn't see any trespass on the GCIC that I recall. Jail was the recommendation.
Okay.
Just to supplement that a little bit, certainly on the Georgia arrests, actually we may be looking at something different because I see the most recent arrest for him in Georgia being theft by taking and also unlawful removal of baggage, cargo, etc. from bus, rail, aircraft, or terminal. That was last year. So presumably that's open. But with respect to his history, he does have some convictions out of Florida, a number of them for public drunk and disorderly conduct within the past 10 years. There was a entering premises after warning conviction from 2023 and other arrests for the same charge, at least around 3 or 4 of them around that time. And I see North Carolina, there were several trespass arrests around 2021. I believe those were dismissed. And with respect to FTAs, there are, all the ones I'm seeing are out of Florida. So it's coming to us from Florida, 2016, 2017, 2018, and 2022. This incident took place on June 11th, 2025 at 464 Windsor Street in Atlanta. It's the King's Food and Liquor store. Law enforcement was dispatched in reference to a criminal trespass call, and upon arrival, made contact with security officer Reginald Kelly, K-L-L-E-Y, who explained the defendant had already been trespassed from the store. He was given that trespass warning on June 9th, just 2 days prior. Officer made contact with the defendant on scene, who admitted that he had been back to both stores earlier, stating that he bought items from inside. Surveillance footage did not reveal him at the times he said he was there. but he admitted to going back. He was taken into custody. Given the history of FTAs and the number of prior trespass cases and that, including that conviction, there's a risk of reoffense here. State's asking for $500 surety. Stay away from 464 Windsor Street Southwest. It's again, the King's Food and Liquor Store in Atlanta. And no drugs, weapons, or alcohol allowed on bond.
All right. PD McLean. Can't hear you. You're on mute.
I'm so sorry. Thank you. Thank you.
Yeah.
He's 59 years old. He was born in Charleston, but he's been in Georgia a good bit. He has a good mailing address at the program at 201 Washington. So he does check his mail, and that and the two or three others are particularly reliable. So he'll get his court notices. We would ask the court if there was any confusion on his part. Well, I try not to get into the facts of the case and leave that for the jury trial, but he did say he made some purchases there, and it was only after buying things that they complained about that it was in violation of the prior warning. I can see a person possibly being confused by that. So, Your Honor, we would ask for a signature bond or $1,000 surety at worst. Thank you.
Well, the state only recommended a 500 surety.
Well, that if it's going to be a surety bond and not a signature, he'd be better off with 1,000 because a bonding company won't touch a 500. They don't make any profit on that.
Mm-hmm. Okay. I see your client has his hand up, I think. I guess you tell him to put it down. Okay.
I can call the courtroom, answer any questions you've got. I'll do that right after we're through.
Could I say something?
All right.
Your Honor, I just
hold on. Your attorney's probably going to tell you not to, especially if it has to do with the facts of the case. I haven't even given a ruling, so I doubt that you would have any questions.
I never talked to an attorney, so how could I have an attorney? I just got in town. How could I talk to them too? I just talked to him earlier today.
Okay. Well, at least you've talked to him. That's good.
Talked to him something I did. I just got in town, so how could he say I live here? I never been here. I just got here. I've been here 3 weeks. I've been from
okay. All right, mute him, please.
For all of them charges.
And you are mute in courtroom too. Thank you.
Well, like I was saying, got the 201 Washington mail drop, which is a program and it's quite reliable. And that was on his 3 card.
All right. I will give him a $1,000 signature bond through the jail. And with that signature bond, he is not to return to 464 Windsor, King's Food and Liquor Store. Do not go there. Whether he's purchasing or whether he's laundering, do not go there at all. You cannot buy any. There's 10 million other liquor stores to go to in Atlanta. No drugs, alcohol, weapons, or guns while on bond. And like I say, stay away from the liquor store. And I guess that'll be it. Now, if he wants to stay in jail, we can change it.
Position number 4.
Didn't hear you.
Position number 4.
Okay. (25 CR 003312B) Robert Barksdale, charged with 1 count of theft by shoplifting. Pretrial.
9 total. On probation, robbery, ag assault, a deadly weapon. 16 SC 143979. I got a robbery, ag assault, 16 SC 144128. Couple of probations from 2024, shoplifting. 2017 and 15 fade to appear.
All right, state.
Yes, Your Honor. The state is requesting a $2,000 surety bond. A stay away from the incident location, which is the Publix at 595 Piedmont Avenue Northeast. An anti-theft course and no alcohol, no drugs, or weapons while on bond. On June 12th, 2025, officers responded to the Publix at 595 Piedmont Avenue in reference to an off-duty officer who needed assistance with a shoplifter. Upon arrival, the reporting officer spoke with the off-duty officer who stated that the defendant walked past the point of purchase with multiple items worth approximately $309.44 before tax. The defendant has stole a steak, soap, toothpaste, baby formula, and other toiletries. And the officer then placed them into custody. State is asking for a $2,000 surety. Stay away from that Publix, an anti-theft course, and no alcohol, drugs, or weapon.
Right. PD Tucker.
Mr. Barksdale is a 32-year-old Atlanta native. He's a high school graduate. He is currently homeless, but he does help support his 3 minor children. He wouldn't be able to afford a $2,000 surety bond. Although he does have a little history, as far as criminal history, he does not have any prior failure to appears. So we are requesting a signature bond on his behalf, given his lack of employment and his status as being homeless. We are requesting a signature bond for him.
Now, I am saying a December 10th, 2024 probation violation in which there was a probation revocation on an FTA.
All right. I'm going to order the $2,000 surety bond. With that surety bond, he is to stay away from the Publix on Piedmont. I don't know if I need to say all Publix, but we'll at least start there. Do not go back to that Publix at 595 Piedmont. No drugs, alcohol, weapons, or guns while on bond. And I guess that's it for now.
Position number 7, Ellison.
$25 CR 0033158 Anthony Ellison, charged with 1 count of simple assault, family violence.
All right, hold on one moment. Okay, he went to felony earlier, got a $10,000 bond, 34 total. He also has a felony bench warrant. 2014 fade to appear, 2010. Possession of a firearm by convicted felon conviction. Possession of a sawed-off shotgun or rifle machine gun conviction. I'd stop there.
Okay, state.
The state is actually requesting no bond in this case, Your Honor. No contact with the victim, stay away from the shared home, stay away from the incident location, which is 644 Joseph E. Lowry Boulevard. And it's the Lowry Food Mart. No alcohol, no drugs, no weapons, and 3 anger awareness courses and the alcohol drug evaluation. On April 15th of 2025, the officers responded to a domestic disturbance at the incident location, 644 Joseph E. Lowry Boulevard. And upon arrival, the officer spoke with the victim, Tabitha Stewart, who is online. And she stated that the defendant threw a big rock at her and she wanted to press charges. The victim stated that they had a verbal dispute outside of 918 Donald Lee Hollowell Parkway, which is a package store. She walked away from that store and headed towards the Lowry Food Mart. The defendant followed her into their store and continued arguing with her inside the store. The victim attempted to leave the store, and when she was leaving, the defendant threw a big rock at her, but it hit the store's door. And the defendant was seen throwing the rock toward the victim's vicinity. The victim stated that they lived together. Upon the officer's investigation of this, they found that there was a 2023 report, case number 232-810358, which he was charged with ag assault and use of firearm by a convicted felon. And the order in that case was he was identified as the predominant aggressor, suggesting a pattern of violence towards the victim. And as a result, he was not to have any contact, no cohabitation with the victim, Tabitha Stewart, and he should not possess any drugs without a prescription, no alcohol, no weapons. And again, it is the state's understanding that they were living together, so he's in violation of that 2023 bond. So the state is requesting no bond, no contact with the victim given that previous charge. Stay away from the shared home. Stay away from the incident location, the Lowry Food Mart. No alcohol, no drugs, no weapons. 3 anger awareness courses and alcohol and drug evaluation. And Ms. Stewart is on Zoom.
Yeah, I was going to say, I do see her. Ms. Stewart,
It's
are you driving?
no, I'm just sitting in the car, the passenger side.
Okay, you're sitting in the car. All right. Do you wish to address the court briefly today?
Yes,
Raise your right hand for me. Do you affirm that the testimony you're about to give is the truth and nothing but the truth under the penalty of perjury?
yes,
All right, put your hand down. Are you in fear of Mr. Ellison?
no,
Do you want to have any further contact with Mr. Ellison?
yes,
All right, do you all have children together?
no,
Okay. All right, and it's stated in the presentation by the state that you all have a shared home.
yes,
All right, is it a lease or purchase?
lease,
Okay, whose name's on the lease?
friend,
Oh, neither of your names are on it?
no,
So you're subleasing from someone else?
yes.
Okay. Okay. All right, that's all I have. Anything else from anyone else? Nope. All right, thank you for getting on. All right. Go ahead, PD.
Yes, Your Honor. Mr. Ellison is a 46-year-old Atlanta native. They've been living at the listed incident location for the last 2 years, or at least Mr. Ellison has. He has a 10th grade education. He's currently, or he was employed with the city of Atlanta, working in the waste department. He's worked there for the last year. He does have 4 children, 3 of which are minors, that he helps support. We would object to him not returning to the incident location. It is his place of residence. Mr. Ellison did state that I believe this residence belongs to his relative, his cousin, if I'm recalling that correctly. So we asked that he be allowed to return to the incident location. We have no objections to no contact with the victim. We are asking for the lowest possible bond that the court would allow in this incident, since it is a misdemeanor charge. We are requesting a surety bond on his behalf.
Well, I usually don't let them go back together or try to displace the victim. I do see that the offense date is in April. And so we're here in June. The victim states that she's not afraid of him, so we'll see what happens and hope that there will be no further incidents. So the state was requesting no bond on this case, and I guess it's because of his extensive history and record.
And also that 2023 charge, and that bond order was to have no cohabitation with the victim. So he's in
Right.
violation of that bond, yeah.
Right, so he's definitely in violation. Usually what I do, and I don't know that he's going anywhere, is a 10,000 felony bond, is I'll just give him a very high bond as opposed to no bond. And so I will give him a $10,000 surety bond. With that $10,000 surety bond, because he's already supposedly not to have any contact with this victim, no further contact with the victim, staying away from that residence, unless if he gets out, he has a police escort to the residence to determine if the victim has moved out. They can sweep that residence. If the victim no longer resides there, then he can reside there. But while he's on bond, he must not reside there and should go live somewhere else. And I think the state asked for a stay away from that Lowry Food Mart. Is that correct?
Yes, Your Honor.
Okay. And as I stated, no further contact with the victim. No drugs, alcohol, weapons, or guns while on bond. And it looks like your client has a question.
Is the question to me, Mr. Ellison? Did you need me to give you a call?
I just want to say that I couldn't violate it when she came around me. That's my apartment.
We're not, this is not a trial. It's a bond hearing. So I'm not going to listen to back and forth about the facts of the case. It's not what I'm here to determine. But you do have orders to stay away.
Can I get the address to, not the store, but the residence? He's to stay away from the residence too, correct? What's the address?
Correct.
To the residence?
Yes, what is that address?
Give me 1 second, Your Honor.
I have
Okay.
590 Joseph Lowry Boulevard, Northwest,
I didn't,
apartment.
can you put it in the chat? Because it was breaking up at the beginning, so I didn't hear. Thank you.
Okay.
Thank you.
So it looks like the residence is near the store. Because the store was Lowry Food Mart. What was the address of the store?
Yes, ma'am. It's the
Okay.
same.
Oh, okay. Gotcha. All right, next case, courtroom 2.
Number 10,
Okay. This is 25 CR 003304J. Xavier, I think it's Keel or Kyle. 1 count of simple battery, family violence.
It's Keel.
Keel, okay. Pre-trial. Oh, first. All right, go ahead, State.
Thank you, Judge. This incident took place June 12th, 2025 at 2751 Rocky Court in South Fulton. Law enforcement responded to a fight call and upon arrival made contact with the victim, in this case, Tamisha Keel, Tymeshia. She explained the defendant, her husband, had gripped her hand in an aggressive manner, squeezing it with his hand and forcing her phone away from her before then refusing to give it back. The defendant initially denied touching the victim, then later stated he and the victim had been in a verbal dispute and he'd taken her cell phone from her due to ignoring him and being downstairs away from him. Victim explained that the defendant had texted her requesting she come upstairs so they could be intimate. She ignored the text and he sent another stating that she was being disobedient. The victim explained the defendant came into the downstairs area, demanded she follow him upstairs, and when she didn't comply, the defendant gripped her hand, the one holding her phone, held it tightly before snatching the phone away
Your
from her.
volume sound went out.
Oh. Where
Now
did
you're back.
Can you hear me?
You said something about after the cell phone, the victim. Something I
Yes.
didn't hear you after that.
Okay. So he gripped the hand that she was holding the phone in, held it tightly before snatching it away from her aggressively. According to Ms. Keel, it's the defendant's belief that she has to serve him in any way due to their religion, and that there have been incidents in the past, but she hasn't reported them due to religious beliefs. The officer observed the phone in the defendant's hand when he arrived and told him he needs to return it. The victim, we have spoken with her. She confirmed they are married and live together at the incident location, sharing no children. She confirmed the events on the warrant. She explained to us that this is not the first time the defendant's been violent towards her, and it's not the first time she's called the police, but it is the first time there's been an actual arrest. She stated that she does not wish to have contact with the defendant and does want him to stay away from the residence. She should be on the Zoom if we could sound for her when appropriate. Given what she's told us and what she told officers on the day of, and the underlying facts alleged here, the state is concerned regarding her safety and a risk of reoffense here. So we were asking for a $3,000 surety bond, $2,000 on the simple battery family violence, $1,000 on the criminal trespass, for him to complete FIB, have no further contact with Tamisha Keel, stay away from 2751 Rocky Court in South Fulton, and no drugs, weapons, or alcohol while on bond.
Give me that amount again. I'm sorry.
The total we were asking for was $3,000 surety, $2,000 on the simple battery, and $1,000 on the criminal trespass.
I think I forgot to say the criminal trespass. Now I realize there was 2 charges. Okay. Is the victim on to Misha Keel? Nope. All right, go ahead, PD McLean.
Your Honor, Mr. Keel is 43. That is their address, Rocky Court. He has an associate's degree in health sciences from a local large college system here, one of our public colleges. He's a truck driver for one of our Atlanta headquartered international businesses. I've got that he has no criminal history. Was that correct?
I have the same.
Okay. But ask the court to consider a signature bond or a $1,000 at worst surety bond. Thank you.
All right. I'm going to order the $3,000 signature bond through pretrial, which will be $2,000 on the simple battery, $1,000 on the criminal trespass. So that's a total of $3,000 signature bond through pretrial. We will be at a level 1. I'm going to have him to take 2-day anger awareness course through pretrial. And this just happened less than 24 hours.
And she wants no contact.
I was gonna say she wants no contact.
And
All right. And a stay away. So no further contact and a stay away from the residence for now while he's on bond. So he needs to find somewhere else to go stay. I will give him a one-time police escort back to the property to get his personal belongings, but it must be by police escort. So arrange that when you get out, Mr. Keel. And no drugs, alcohol, weapons, or guns while on bond. And unless you have a question about the bond conditions, there's no other things that we need to hear from you today. Do you have a question about the bond conditions?
No.
Okay. All right. Thank you.
Number 8, Franklin.
This is 25 CR 003316H. Taurus, a Terrace Franklin, charge of 1 count of loitering prowling.
52. On probation, forgery in the third. Got an open possession of drug-related objects, identity theft, fraud, theft by receiving, giving false names. 24 PI 001562. 2024 probation. 2019 probation. 2019 and 18 parole violation. 2018 fade to appear.
The state is requesting a $2,000 surety bond. Stay away from the incident location, which is 120 North Avenue Northwest in Atlanta. No alcohol, no drugs, no weapons, and an anti-theft course. On May 11, 2025, the defendant was observed on cameras walking up to the bike rack at 120 North Avenue Northwest, where he was looking at the bikes that were secured on the bike rack. He then walked away and took a seat on the nearby bench area. Then he was later seen walking back towards that bike rack and then manipulating the locks. Officer addressed him about this matter, and he said that he wasn't touching any bicycles, but just observing them. But the camera footage did determine that the defendant did go to the bicycle rack, and he was actually manipulating the locks on those bicycles, none of which that he owned. And the state is, given his lengthy criminal history, some being theft charges, the state is requesting a $2,000 surety bond. Stay away from the incident location, no alcohol, no drugs, no weapons while on bond, and an anti-theft course.
All right. PD Tucker.
Yes, Mr. Franklin is 56 years of age. He's lived in the Atlanta area for 40 years. I do have a good address on file for him. He's obtained a bachelor's in business management. I don't believe he is employed currently, so he would not be able to afford a $2,000 surety. We are requesting a signature bond on his behalf, although there is a FTA in his history. It is older. So we are requesting a signature bond. We have no objections to the stay away. We do object to the anti-theft course. I don't see anything in the affidavit regarding manipulating the locks. And there's no theft charge here. It's a loitering charge. So we are objecting to that recommendation from the state. Otherwise, we have no further objections at this time.
Okay. This is a bit because of his extensive criminal history. I wonder, I don't know if he's coming back or not, but I'm going to order the $2,000 surety bond and stay away from the incident location. No drugs, alcohol, weapons, or guns while on bond. And he has his hand raised.
If you need me to answer any of your questions, I can give courtroom to a call regarding your bond.
I was trying to get the signature bond. I'm in a PAD program and I have meetings I have to make at 10 Park Place for my McKinsey that I can't miss.
Say that again?
I'm in the PAD program and I have to go to 10 Park Place for my case assessments for my McKinsey. And if I miss them, they start me all over again, man. I was just requesting the signature bond, if possible, please, because I can't afford a bond, man.
And what is the, do you know, PD Tucker, what's the tag program?
Are you saying PAD program?
Oh, he's saying PAD, PAD. Oh, he's in PAD. And when you're in PAD, you're supposed to not get any additional offenses while in PAD.
Yes,
Correct?
ma'am. Yes, ma'am. I stopped to smoke a cigarette and I seen a Neo Russo. It's a particular beach cruiser. And all I did was look at it, ma'am. I wasn't manipulating a lock. I didn't have no tools to take a bike or anything. I just was looking at the bike when I went and shut back down.
You have anything to add, States?
Nothing further, Your Honor.
When do you have to report to PAD again?
I don't have to report the fact. I do believe it'll be Tuesday that I have to be there, ma'am.
Tuesday that you have to be there?
And Tuesday I had to be at 10 Park, Tuesday.
All right, I'm gonna try to give you a chance, but you need to be careful. I'm going to give you a $2,000 signature bond. And I would put you on pretrial, but I'm gonna trust that you're gonna do the right thing. So 2,000 signature bond through the jail. And no drugs, alcohol, weapons, or guns while on bond. But I'm gonna ask that you stay away from that incident location. I don't know that do we have an exact address? Because I know the bike rack may have just been on the street somewhere. Do we have a location, an actual address?
With the warrant, it said 120 North Avenue Northwest on the warrant.
All right, so stay away from that area. And don't look at no bikes and you'll be okay. You know, we'd like to see you complete the PAD program. All right. That's it. No drugs, alcohol, weapons, or guns while on bond. All right.
Number 12.
So Tuesday, no, signature bond.
You know, see.
This is 25 CR 003307F, Thomas Probst. 4 counts of willful obstruction of a law enforcement officer.
You
Pretrial.
got $6,000 bond and felony earlier. 18 total. Got an open sale of possession of a controlled substance. It's 24 SC 001393. Open burglary first degree out of DeKalb County. 2023 probation, 2022 obstruction conviction. You got 2 FTAs from 2017 and a shoplifting NOLO 2017.
Okay. State.
Thank you, Judge. This incident took place June 11th, 2025 at 205 Moreland Avenue in Atlanta. Law enforcement were at the location. They observed the defendant walking eastbound at there, and he was a known suspect in the area who had previously fled from the officer on June 1st, 2025 in connection with a stolen moped investigation. When the officer made contact with the defendant, these were ultimately 4 officers, hence the 4 charges here. The defendant took flight immediately, ran roughly 50 feet before he was brought to the ground, and all the officers had attempted to place him in handcuffs, stiffened up his arms, and was lying prone to try and prevent himself from being detained. When initial contact was made, the defendant, it was revealed, had 2 warrants out for his arrest. 1 warrant out of Fulton for failure to appear, and that is 25 FTA 001136. That is failure to appear for the previous case mentioned, the 24 SC 1393 case. And also wanted out of Cobb County for obstruction. He was, excuse me. Yeah, that about covers it. He has there's a bit more to his history, that you heard about that willful obstruction conviction from 22. He received first offender treatment for felony fleeing and eluding, but he was convicted of DUI, driving while license suspended or revoked, and willful obstruction in 2018. He has resisting a public officer conviction, 2009, fleeing and eluding, 2007, assault on a government employee and fleeing and eluding in 2004. Those ones I mentioned there were out of North Carolina. And with respect to his open cases, he has there's a 25 PI 004710, theft by receiving and willful obstruction. The one that pretrial mentioned earlier that he had the FTA for also has a willful obstruction charge associated with it, as well as a reckless driving and a fleeing and eluding. And yeah, that about covers it. So this defendant has a history of obstructing law enforcement dating back several decades and continuing today with this case, the one out of Cobb, and the others. So there's clearly a risk of reoffense here. That with his open FTAs, of which there are at least two, I guess one now, but there is a risk of failing to appear as well. So the state is asking for $2,000 surety, $500 on each count, no drugs, weapons, or alcohol while on bond.
Okay. Okay.
Your Honor, he's 44 years old, has a BA in advertising from Appalachian in Boone, North Carolina. He works construction. He has a Farley Mill address in Marietta, so he's local and born in Georgia. His contacts, I noticed from the area code, are local. We would ask the court to consider a signature bond. If the signature bond is impossible, then we would ask the court to consider $1,000. Thank you.
All right, I will order the $2,000 surety bond, $500 on each of the charges. Stay away from the incident location on Moreland Avenue. No drugs, alcohol, weapons, or guns while on bond. That should be it. Anything else?
Nothing,
No.
Mr. Judge.
Nothing. Thank you.
Okay.
Can we do the position number 16? The waive.
Okay. This is 25 CR 003308F. Taekwon Williams Francois. Charged with 1 count of criminal trespass, 2nd count loiter and prowl. And
Yeah, 13 total. He went to felony earlier, got no bond, so he'll be sitting tight. He's
Okay.
on probation for burglary, entering auto, 23 SC 181877. Another entering auto, 23 SC 189462. 2024 probation. 2020 financial transaction card fraud conviction. And he got several more probation violations.
okay.
Thank you, Judge. This incident took place April 30th, 2025 at 549 8th Street, Northwest Atlanta. It's one of the parking decks of Georgia Tech, the Curran deck to be specific. Law enforcement responded to that deck in reference to an entering auto incident where the officer made contact with Miss Jolie Zeneda Claudio, who explained that she had been moving boxes and had parked her vehicle on the lower level and accidentally left her doors unlocked, she believes. And when she returned, she discovered a black ski mask in the driver's seat. She inventoried her vehicle, reported the only item missing was some loose change. And surveillance video, when reviewed, showed an unknown male wearing certain articles of clothing, he was going in between different vehicles and looking into said vehicles, pulling on door handles. At one point, he was seen to run in between vehicles with no mask on, and then came back out wearing the same full-face mask that was recovered from the victim's vehicle. He was recognized from previous cases when comparing the surveillance images, and it matched the defendant in all respects. He was previously issued a lifetime ban from Georgia Tech property on February 7th, 2022, making his presence a criminal trespass. As you've heard, quite the history here, quite the recent history here, and a lot of it is fairly related, I would say, with respect to the entering autos and the criminal trespass. That one that pretrial mentioned had 3 counts of entering auto burglary in the first, 2 counts criminal trespass, that conviction, and the ones he's being held on right now are, it's 25 PI 00, and it's 4720, 4721, 4722, and 4723. Altogether, it's entering auto, 3 counts of that, several counts of financial transaction card fraud and theft, 6 counts of criminal trespass, and a theft by taking charge. And on that burglary in the first conviction, that was actually also a Georgia Tech PD case as well. As well as, he's got the first offender treatment was revoked for a 2019 case for entering auto. So with his history and his open cases here, it's no secret what the defendant was doing on this parking deck. He poses a risk of reoffense and a risk to property in the community. So the state is asking for a $5,000 surety, $2,500 on each count. Stay away from all Georgia Tech premises and property, and no drugs, weapons, or alcohol while out on bond.
Okay.
Your Honor, he is 28 years old. I've been in touch with his dad. I told the family I would inform them of the disposition of today's hearing after it's over with. He understands what he's charged with, and he asked the court to, he's waived his presence. He asked the court to set the lowest bond that would be appropriate.
All right, I will order the $5,000 surety bond, $2,500 on each. Stay away from Georgia Tech campus, the whole campus. It might be all the downtown by now. So stay away from Georgia Tech since he's not a student there. No drugs, alcohol, weapons, or guns while on bond. And I guess no further contact with the victim.
Yes,
You
Judge.
just want that, yeah. I know he may not know her, but
Right.
we'll just say that.
Could you possibly run through that breakdown one more time?
2,500 on each, charge 5,000 surety.
Okay, thank you, Judge.
Mm-hmm.
What's the victim's name?
Zoe.
Jolie,
Jolie.
Claudio.
Jolie.
Position number 6, and he's a waiver as well.
Okay.
Can you put the name in the chat, Mr. Sirocco? Thank you. Sorry, Judge.
Uh-huh.
You stated position number 6.
Yes.
Could we go into a breakout just really quickly on that case? Really quickly, Your Honor.
Okay.
Yeah, that was the report. This is an MH case.
Oh, okay.
Who all needs to go in there breakout, Judge?
Everybody left. I think is it just the 4 of us?
It's just the court staff here now.
Oh, that's right. I'm sorry. We do have one other person. Got courtroom too. We'll go in there real quick and talk about
No, we
it.
don't have anybody else in the courtroom, just court staff.
Oh, well, then you can stop us from streaming. And we won't have to do the breakout since nobody's here. And no one else is online, right, Casey?
No, ma'am.
Okay.
And we didn't get an interpreter for that case, the Mandarin one.
No,
Okay.
Case to be
that was
reset
gonna
for
have to
tomorrow.
be reset to tomorrow. I think they were trying